In my line of work, I get nothing but questions, which is totally okay. I love questions. But at the same time, today I wanted to make a video about all the questions that I get. Well, not all of them, of course, but the main ones that I get, and I wanted to kind of answer them so that you guys can have that information as well. It's fascinating because everybody comes in all shapes and sizes, and trust me, these questions still pop up, I'd say 80 to 90% of the time. So with that, if you have any questions on this, you can go to my website, www.legionlawpllc.com. You can schedule a free consultation over the phone with me to talk about this or any other questions you have. So the most frequent question I get is actually, how do I avoid probate? What's my process to avoid probate? I don't like probate. It sounds scary. It is bad. So therefore, how do I avoid it? And that is probably the best question I have because, good Lord, it is an important one to ask. For those who don't know, probate is the process by which we get a judge to sign off on you able to transfer from assets from one person to another. However, that process takes 3 to 4 months. In the best case scenario, it can cost $5,000 to $10,000 in Texas. It can go from 3 to 12 months even, and everything's frozen during that time. So it's an awful process that people go through after someone's passed away, which is the worst time to deal with legal paperwork whenever your loved one is in the ground. You want to mourn instead. So instead, how do you avoid probate? There are many different ways to approach this. I've made many different videos in depth, but I'll kind of approach it from a 10,000 foot view right now. The most common way is to create a trust, transfer your assets into the trust, and then you put yourself in charge of the trust. And by doing that, once you die, you put a new person in charge of your trust, and your trust lives on beyond you, and therefore you avoid probate with any kind of asset inside that trust. We only go to probate if someone is dead, and if the trust doesn't die, then we don't have to worry about probate. Another way to do it is beneficiary designations. Those auto-transfer assets from one person to another after someone's passed away. And there are ladybird deeds or transfer on death deeds for real estate, or you can just put it in a trust. That's usually the general process on that front. Another question I have is, well, I drafted a will. It's all valid. It has exactly what I want. I get to avoid probate, right? And the answer is no, you don't. You get to avoid the terrible probate, the worst probate, but you go through a faster, cheaper form of probate. And so when I say faster and cheaper, I mean 3 to 5 months, $4,000, $6,000 versus 7 months and $10,000. So it's kind of like saying, hey, instead of eating a whole crap sandwich, I eat half a crap sandwich, right? But it's still a crap sandwich, and that's not good. So that is a very common misconception. Please don't fall into that category. It's a bad question to believe because you think, I'm okay, I have a will, everybody tells me to get a will, I'll be fine. But no, we need to validate that will. And the last one that I get usually is, hey, I've been married for 30 plus years. I'm totally okay. My wife and I, we do everything together. After I die, everything goes to her, right? Like, how does it not go to her? And the answer is that, well, in Texas, we still worry about your authority to sign on your wife's behalf. Only she can sign for her. You cannot sign for her, even if she's still alive. So we still need to go through probate, even if you guys had the best relationship ever, even if you were the paragon of love and care for one another, it does not matter. You could be married for 1 day, you could be married for 30 years. At the end of the day, every single married couple is still going to probably go through probate if they haven't set up an estate plan ahead of time. So you still need the authority to downsize the house. You'll still need her signature to close her bank accounts. You'll still need her signature to access her retirement accounts. All sorts of different scenarios, no matter what type of relationship you had and no matter how close you are with your bank or with your title company or whatever else, they're still going to need that authority through probate. So if you have any questions on this or anything else, those are kind of the main questions I get, but those are really, really important ones to answer. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can go to my website, www.legionlawpllc.com. You can go to the Contact Us page and schedule a free consultation over the phone directly with me. So thank you so much and have a great day.